Other types of delegated legislation. In addition to the general procedure described before, SIs are created in a variety of other forms. We will discuss the more common ones here. The list is not comprehensive. There are various types of instrument outside the scope of this lecture. The first one is the legislative reform orders. The passing of the Regulatory Reform Act 2001 enabled the government to make an order known as a Regulatory Reform Order to amend or repeal a provision in primary legislation which is considered to impose a burden on business or others as long as it can be reduced or removed without removing necessary protection. In 2006, the Legislative and Regulatory Reform Act was passed, which, like the Regulatory Reform Act 2001, gives ministers certain powers to make orders that remove or reduce burdens resulting directly or indirectly from legislation. Section 2 of Legislative and Regulatory Reform Act makes similar provision about orders that promote principles of better regulation. Section 3 of the Act sets out fact that the minister proposing to make a legislative reform order has to address. The minister has to ensure that there is a need for legislation and there is no removal of necessary protection. The minister can only proceed if satisfied that all relevant Section 3 tests are passed. Before a minister may take a legislative reform order, he or she must consult widely with those affected by the proposals, lay before Parliament a draft order, an explanatory document, and allow time for parliamentary consideration. Obtain Parliament's sanction for making the order unless the negative procedure is used. Only after all of these steps have been successfully completed may the order become law. The second are remedial orders under the Human Rights Act 1998. If a court makes a declaration of incompatibility with the European Convention on Human Rights in relation to a statute, the government is able to propose draft orders or make orders to amend primary legislation in order to remove any incompatibility. The procedure followed is similar to that for regulatory reform orders. First, a minister must lay a proposal for a draft remedial order before Parliament. The proposal must be accompanied by an explanation of the circumstances that led to the need for the proposal. Also, during this process, the Joint Committee on Human Rights must report on whether an order is the same terms as the proposal should be laid. Once the order is approved by the both houses, it may be made and brought into effect. There is also an urgent procedure for remedial orders, where the order is made at the same time as it is laid before the Parliament. The third is the Public Bodies Orders. The Public Bodies Act 2011 gives ministers the power to abolish, merge, modify the constitutional arrangement of public bodies. Before a minister can lay a draft order under this act, a consultation process must have been completed. Once the consultation process is completed, a minister may lay a draft order. The fourth type is commencement orders. Commencement orders are a form of SIs designated to bring into force the whole or part of an act of Parliament which for some reason it is not desired to put into effect immediately upon royal assent. There is in general no requirement as to the time after royal assent in which such an order must be brought in. For example, the Easter Act 1928, which stipulates a fixed date for Easter, has not yet had a commencement order made, though it is open to the Home Secretary to make one if general agreement on fixing a date is reached. These are not subject to parliamentary procedures and are simply made. The fifth one is the Orders in Council. Orders in Council are issued by and with the advice of Her Majesty's Privy Council, and are usually classified as secondary legislation, although some can be primary legislation, and are made under powers given in a Parent Act. They can be used for a wide variety of purposes, but most frequently when an ordinary SI would be inappropriate, such as transferring responsibilities between government departments, or where it affects the Constitution by extending legislation to the Channel Island, for example. An example of the latter is the Afghanistan Order in 1999, which gave the Channel Islands legal authority to implement sanctions on Afghanistan. Orders in Council were also used to transfer powers from ministers of the UK government to those of the devolved governments. Examples of these are the Scotland Act 1998, Transfer of Functions to the Scottish Ministers, Order 2006.